All right, here we are for Unit 6. We're going to talk about some legal issues. I'm actually going to follow your reading this time more than I have in any other lecture, and as a consequence, this won't be a very long lecture because I trust you're doing the reading, you're grown-ups, and frankly, I expect you to do the reading that's assigned. So, and I expect that you will take a good look at it and try to glean as much from it as you can. Nonetheless, there are some things in the reading here that I really think probably merit some additional discussion, and I do want to talk about some aspects perhaps of the reading that maybe were not really discussed as much as I would have liked. But nonetheless, we'll be brief. First, let's talk about fraud in a negotiation. Now, when we're talking about fraud, we are talking about the following, and I'm going to read from a case. The name of the case is Winn, W-I-N-N, versus Aleda, A-L-E-D-A Construction Company. Excuse me. And that is found at 315 Southeast 2nd, 193 or 227 Virginia 304. It's a 1984 case from Virginia, a case I cited innumerable times over the years while I was practicing in Virginia. And here's what it gives: the basic elements of fraud. You have to have 6 things: a false representation of a material fact made intentionally and knowingly with intent to mislead, reliance by the party misled, and resulting damage to the party who is misled. Now, that's a standard and very classic definition of fraud, and it applies in negotiations if and only if, in fact, all 6 elements are met, just like it would apply under any other circumstance. In other words, and I don't think the book really made this clear, can you be guilty of fraud during a negotiation? The answer is yes, you can be. You might say, well, wait a minute. What about puffing? What about other things? Well, let's take an example, okay? And let's do something simple. Let's do a personal injury case where the plaintiff is in a car accident and both cars suffer very mild property damage, and the person making the claim, who let's say gets rear-ended, we'll make it simple. They're sitting at a stoplight and the other person just bumps them from behind, and the person who's driving the car that gets hit from behind goes to the emergency room to get checked out and suffers really no significant injury, a little bit of neck pain. They go to their family doctor the next day or the day after, and the family doctor says, looks like you're going to be fine, take some Motrin, call me in the morning, kind of thing. And that plaintiff maybe gets a week of physical therapy and then is fine and feels great, says, yeah, I'm fine now, and then makes a claim. Now, let's say this person goes to an attorney, and the attorney contacts the insurance adjuster and says, here's our medical bills, and we're asking for $5 million, that's million with an M, dollars. Now, the insurance adjuster chuckles, and the attorney says, I'm not kidding, my client will accept $5 million. Now you say, well, okay, let's look at the elements, right? You say, well, isn't that a false representation? Well, no, it's not. Okay? Why isn't it? Because the plaintiff will, in fact, take $5 million if some insurance company was stupid enough to give him $5 million for that case. All right? So it's not false. We start right with the very first element. It is not a false statement. You might say, well, what about puffing? Or what about, but the attorney knows that they're not expecting $5 million. Well, there's a big difference between what you expect and what you ask for. You can ask for anything, right? Isn't that the old saying? I mean, think about it when you went to your parents when you were a kid, right? And you really wanted whatever it is that you wanted, right? You went and you asked, even though your expectation was, well, I'll never get that. But oftentimes, maybe not for all of you, but certainly for many of you, oftentimes you went to mom or dad, or mom and dad, whatever your circumstance was, and you asked kind of for more than you wanted, thinking, well, if I ask for extra, if I get it, hey, heck yeah. But if not, well, at least I'll get kind of something close. And the same principle applies here, and that's really not fraud. Okay, that's just not fraud because you will always take the greater. Now, what about on the other side? If you are someone who has a demand for something foisted upon them, and the same principle applies. Well, no, let's say I'm the claims adjuster in the example I gave earlier with the small impact automobile accident, and I say, well, we can pay $500. Well, is that true? Yes, it is. And see, it's not a false representation. It is in fact true. The insurance company can, in fact, pay $500. So that's not what we're talking about here with fraud. We're talking about fraud in the sense that a piece of information that the person who is communicating it communicates it knowing, not a demand, not a request for a resolution, but communicates a piece of information, more than likely a piece of factual information. Let me fix up my car accident example. Suppose that I am the attorney representing this person who is in the car accident case, and I say, my client is going to need neck surgery. And the insurance adjuster says, well, that's kind of surprising. This is a minor accident, and it just seems a little odd that you would need neck surgery because of the accident. And I say, my client is going to get neck surgery. And what I don't tell the insurance adjuster is, well, my client was getting neck surgery anyway. It was already scheduled. It was scheduled before the car accident. But the insurance adjuster at this point doesn't know that fact. I know it. The insurance adjuster doesn't. I cannot do that, particularly as an attorney. I am misleading that insurance adjuster and trying to get that person to think that, in fact, my client needs the neck surgery because of the accident, even though I never say that, even though I never utter the words, well, this accident is going to result in my client receiving a neck surgery, or getting a neck surgery, or because of the accident, my client is going to have a neck surgery. I don't say any of that. I just throw it out there, and I'm telling the truth, right? My client is, in fact, going to have neck surgery. Problem is, it has nothing to do with the car accident. Now, I know it. The client knows it. The doctor knows it. Everybody involved with the neck surgery knows my client is not having that neck surgery because of anything related to this car accident. That's fraud. That's wrong. That is illegal. And if you are an attorney, or you're working with an attorney, or you are consulting with an attorney, or you have hired an attorney, you cannot have your attorney do that. It's just that simple. That would be improper. A, it's legally fraud. B, it's just unethical. Okay, because again, Rule 4.1 of the model rules, you can't knowingly make a false statement of fact like that. You just can't. It clearly meets the requirements if the insurance company pays on that case with the mistaken assumption that there's going to be a neck surgery. That's really improper. On top of everything else, look, from the Christian standpoint, with me as a Christian man, I can't do that. Now, if my client says, I want you to mention the neck surgery, I'm going to tell the client, well, I'll mention it, but I'm going to tell them the truth. Now, if the client says, no, I want you to just mention the neck surgery, don't let them know what's going on with the neck surgery, then, of course, my response has to be to fire my client. And that does happen. You basically at that point have to say, listen, you're asking me to commit fraud. I'm not going to do that for you. That's against the ethical rules. It's illegal, and quite frankly, it's immoral. And so I'm not going to do it. I'm sorry, you're fired. And you fire the client. Oh well. You never want to do anything like that for a client. You're better off without that client. All right, so that's fraud. That's a long excursion into fraud. We won't spend as much time on the other topics. Second big thing, you may not, and you cannot make threats, extraneous threats in particular, of criminal action in order to gain advantage in a civil matter. If you are negotiating in a civil case, you are not allowed to tell the other side, well, we're going to report you to the state police, or we're going to call the FBI, or blah blah blah, if you don't concede to or don't acquiesce to our demands. Well, you can't do that. You can't do that. The rules don't allow it and don't permit it for obvious reasons. That's basically a kind of blackmail or extortion or whatever words you want to use. It's not appropriate. Uh, some years ago, many years ago, okay, some of you weren't even alive when this happened, undoubtedly. There was an attorney back in the area where I practiced who really made a huge mess of things. He committed a lot of fraud. Okay, maybe he was a bad man, committed a lot of fraud, cheated a lot of people out of money, including the government. Another attorney who got a hold of a case involving this man threatened to expose him to the government and said, you know what, I know what you've done is fraudulent, but I'll keep my mouth shut if you give us a bunch of money. Well, the guy who committed all the fraud, he ended up shooting himself. That's how bad it was. He stole millions. I mean, he just stole millions. The guy who threatened to expose him to criminal sanctions was sanctioned by the Virginia State Bar, lost his license for a year. So lawyers take that kind of thing very seriously, as does the bar. So if you're an attorney, you never want that to happen to you. You can't make those kind of threats. Second, you can't threaten violence, obviously. I mean, I hope I'm preaching to the choir here, right? I hope, right? You can't do that. I mean, that's crazy talk. If you're involved in a negotiation and you're an attorney, or you have some connection to an attorney, as you get involved in the negotiation, you simply cannot resort to threatening violence or threatening to do anything illegal that might harm someone else. I mean, that should be self-evident, I would believe, and I hope for all of you. And on top of everything else, again, as a Christian, you just don't do that. If your case stinks, your case stinks. Oh well. If your situation is weak and your circumstances are weak, you do everything you can within the bounds of the law to make it look as good and as strong as possible, but you just can't resort to those kinds of tactics. They're just completely inappropriate. And they're just, frankly, again, immoral. And I don't mind saying things like this. Look, it's immoral. It's wrong, right? So just don't do it, right? A couple other things, last things. Offers of judgment. Two last things. Offers of judgment, and then kind of devices for settling multi-party cases. Offers of judgment are a peculiar feature of some states. Virginia, for instance, has no offer of judgment mechanism. It just doesn't exist under Virginia law. Offers of judgment work in this manner. Rule 68 of the federal rules. In Kentucky, where I live right now, it's Rule 68 as well. And what offers of judgment do is this. The defendant in a case, and this is actual litigation is pending, the defendant decides, you know what, I'm going to offer to accept judgment in a certain amount. And the plaintiff then has a period of time. In Kentucky, it's 10 days. In federal court, I think it's 14 days, or maybe I've got it reversed. I can't remember now. It's one or the other. You can look up Rule 68 and find out. The idea behind it is it's an attempt to end the litigation immediately. And so the defendant says to himself, herself, itself, whatever the defendant is, I wonder how much money it would realistically take for me to just sweeten the pot enough that the plaintiff takes the money. Now, here's the thing about offers of judgment. You got to recognize and understand. And the book really doesn't get into the tactics of it, so it sort of talks about it in this dry way. This is a device that just simply only defendants have this, and what they are able to do is kind of think through what would be just enough money to make it risky for the plaintiff to keep moving forward with the litigation. Because here's the catch. If I, as a defendant, make an offer of judgment, and you as a plaintiff don't take my offer, then all costs I incur for the rest of the litigation, which might mean deposition transcripts, for instance, It could mean, it probably does not mean expert fees, probably. I don't know the federal rule. I know in Kentucky, I don't think it does. It does not mean attorney's fees, but it does mean things like depositions, video fees for depositions if you have a videotape deposition, the cost of the transcript, the cost of the court reporter, that adds up quickly. Cost of subpoenas, if you have a bunch of witnesses, that can add up very quickly. If the case gets continued 2 or 3 times, which happens all the time, trials get set, they get bumped or moved or get continued for a variety of reasons, and so those costs can add up. And you could easily, as a plaintiff, end up paying $3,000, $4,000, $5,000, $6,000 towards costs along the way, depending on the nature of the litigation. And so the defense then has an opportunity to sort of figure out, well, how much do I give the plaintiff in order to just get them just anxious enough to take my money. That's kind of the idea. It's not easy to figure out. Now, I will tell you, the office where I work, we had a personal injury case. We do a lot of personal injury cases, and the defense attorney made an offer, and my boss looked at it, and I looked at it, and we bandied about what would we do with this offer of judgment, because it was just enough that it made it impossible, and we had to take the money. And we really thought the case had more value than the offer of judgment that was made, but it was so close to what we realistically thought we could get, and the problem was, what about costs? Because here's the thing, while the defendant is accruing litigation costs, so is the plaintiff. So it's a double whammy if you're the plaintiff. And so we had to take the money. So it works. It can work if the defense is savvy enough to make a good offer. All right. Last 2 things. One is high-low agreements, and the book talks about Mary Carter agreements. I never called it a Mary Carter agreement, but I engaged in those kind of agreements many times when I was a defense attorney, where I would make a side deal with one defendant. I don't know that I ever actually tried a case where the defendant had already made a deal with me and was just sort of standing there doing nothing while we litigated. I don't know that I was ever involved in anything quite like that. What we used more often were something called high-low agreements, where the parties would go into trial with preconceived parameters already negotiated. In other words, the plaintiff agreed they would only take X, which was the high, and the defense agreed to pay Y, the low, no matter what happened. And so it guaranteed the plaintiff a bottom line, but it capped out the defense's potential exposure. And the main reason that I did that on a number of occasions was because I had clients who had insufficient insurance coverage, or at least potentially insufficient insurance coverage, and we would cap out the amount of money they could possibly owe within their coverage limits. And that let me try the case without worrying about whether it might expose my client to what we would refer to in the business as an excess verdict. And so we did that all the time. The Mary Carter agreement idea is basically that the plaintiff and some defendants in a multi-defendant case just agreed to a deal in advance, and then the case just goes forward as if it were being litigated normally, and the only people who know about the deal are the defendant and or defendants who've settled with the plaintiff and the plaintiff. The rest of the defendants don't know, neither does the jury. If I were doing that, one caveat, I mean, that's an acceptable way to do things in most states. If I were doing it, though, and I would tell the judge. If I were you and I'm an attorney and I'm standing in front of a judge litigating a case and the judge doesn't know about this deal, I would feel really uncomfortable. I would ask to see the judge in private. Say, Judge, I need to speak to you about something in private, and I would explain to the judge, hey, this is what's going on. I need you to know. I want you to know this so that you understand we're not pulling something funky on you, because judges don't care for that. All right. Last thing, very last, and then I'm done. I guess I've probably gone longer than I thought, but get everything in writing. So when you finish a negotiation, get it in writing. Okay. And that could be as simple as an email. It doesn't have to be complicated, particularly if the subject matter is not complicated. And I will tell you, I've done a lot of look, I've done a lot of personal injury defense and a lot of personal injury cases over the years, both. And some attorneys just want to make everything into, they want to make a mountain out of a molehill because they feel like they're a lawyer and they've got to justify their existence, and therefore they have to write a 5-page release for a car accident case. That kind of nonsense is, in my estimation, I mean, it's just me. Okay, maybe I'm just getting grouchy in my old age, but that's just dumb. Okay, it's not necessary. Now, it's important that you have basic things in any settlement agreement, of course, but don't overdo it. You don't need to. I mean, put what you need in. Particularly, and one thing you can always do, and I recommend this highly, let's say you work out something where the main issue are some numbers, okay, dollars and cents in particular. Get it done with an email. Hey, this will confirm we settled the matter, or we've resolved this, or we've agreed to whatever wording you need to use for $1 million. We've also agreed to the following 3 other stipulations, A, B, C, and write them down. Send the email. And the email can say, this will be followed up by a full settlement agreement. I just wanted to confirm that, the basic information with you and make sure this is accurate before I generate a final, settlement agreement or something like that. That way you've got the basics down, and you can always, get your language together and get everybody to sign off on it later. And you can, that's when you can have whatever fun you want to have beating up on each other about the words in the negotiated settlement document. But get the big stuff done, even if it's just simply by email. So that's it. I guess I went about 20 minutes, so a little longer than I hoped, but hopefully you got something out of this. I'll have some work for you to do, and very shortly, probably in the next couple of days, I will give you your first negotiation assignment. And let me just say a word about that since I've sort of got your attention here. What will happen with the first assignment is I will pair you up. You'll be scheduled in pairs, and I will tell you to engage in a email battle of, if you will, back and forth, in which you copy me. I'm going to set up, so that it doesn't get lost in a gazillion emails, I'm going to set up a special Gmail account specifically for this purpose. All right. And that's typically not what they want me to do, but I get so many emails from so many different places that I can't keep up with it. And this way I will be able to, even if you just CC this email address, it'll be a focused email address, which I will get set up so that I can see what you're doing, and I don't have to weed through any other emails. It'll just be for that purpose. So I'll explain more on this. I'll send an email to everyone kind of outlining what I will expect of you in this email negotiation that will occur the second to last week. And then if everything works as according to Hoyle, we will have a video negotiation between, again, I will pair you up and you'll negotiate, and we'll let's keep our fingers crossed because we'll see how that works out. All right.